You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The Right to Financial Privacy Act, or RFPA, provides one of the earliest examples of how lawmakers sought to balance individual privacy with legitimate investigative needs. Passed in 1978, the statute was designed to stop government agencies from freely obtaining people's banking records without oversight. It requires federal authorities to obtain either a warrant, subpoena, or formal customer authorization before financial institutions can release personal banking information. This process ensures that citizens' financial data is not subject to unchecked surveillance or administrative convenience. For learners, the RFPA represents a critical privacy milestone because it established the principle that records held by third parties, like banks, are not automatically open to government review. Banks are required to protect sensitive data unless proper legal channels are followed, reaffirming that due process serves as a guardrail even when the government's goals are rooted in law enforcement. The Bank Secrecy Act, or BSA, illustrates the opposite dynamic by imposing obligations on financial institutions to report certain information to government authorities. Enacted in 1970 and expanded over the decades, the BSA requires banks to submit suspicious activity reports and currency transaction reports whenever transactions cross designated thresholds or appear linked to criminal activity. Customers are generally not notified when such reports are filed, creating a tension between transparency and secrecy. For learners, the BSA underscores that privacy obligations do not always mean non-disclosure. Sometimes institutions are legally mandated to share information, particularly where national security or anti-money laundering goals are involved. The dual nature of the RFPA and BSA highlights how privacy law is not absolute but conditional, requiring organizations to navigate between protecting customer confidentiality and complying with proactive disclosure requirements to support broader public interests. The Electronic Communications Privacy Act, or ECPA, passed in 1986, extended protections to electronic communications at a time when email and online storage were just emerging. The Act has three primary titles: the Wiretap Act, which governs interception of live communications, the Stored Communications Act, which regulates access to data held in storage such as emails or files, and the Pen Register and Trap and Trace provisions, which control real-time collection of dialing or routing information. The ECPA attempts to create tiers of protection depending on whether communications are in transit or stored and how long they have been held. For learners, this law illustrates how difficult it can be to align privacy with rapidly advancing technology. The original text assumed email older than 180 days deserved less protection, a standard that now seems antiquated in the cloud era. This mismatch shows how laws must be revisited to maintain relevance as digital life evolves. The Communications Assistance for Law Enforcement Act, or CALEA, adds a structural requirement for telecommunications carriers by mandating that they design systems capable of supporting lawful intercepts. Unlike the ECPA, which addresses how investigators gain access through legal process, CALEA is about the technical design of networks. Carriers must ensure that wiretaps or intercepts can be executed when authorized by a valid warrant or court order. This does not mean constant surveillance, but it requires that the infrastructure itself is built with capabilities that make compliance feasible. For learners, CALEA embodies the principle of lawful enablement, reinforcing that private sector systems must support investigations under the right conditions. However, it also demonstrates the persistent concern that such backdoors or intercept enablement features may create vulnerabilities or potential misuse, sparking ongoing debates about security, privacy, and law enforcement balance. One of the most important distinctions for practitioners is understanding the differences among subpoenas, court orders, and warrants. Subpoenas, often issued by prosecutors or administrative agencies, compel production of basic identifying information like subscriber records. Court orders, which require judicial oversight, authorize access to more detailed metadata such as call logs or transactional data. Warrants, which demand a showing of probable cause, allow investigators to access the full content of communications, such as stored emails or documents. For learners, recognizing these categories highlights the principle of proportionality. The more sensitive the data sought, the greater the judicial scrutiny required. This structured hierarchy ensures that investigators cannot casually obtain intimate content, and reinforces the idea that stronger legal safeguards must accompany deeper intrusions into personal life. It demonstrates how due process calibrates privacy protection in line with the sensitivity of requested information. Preservation requests illustrate another procedural nuance in this landscape. Law enforcement can issue these requests to require service providers to preserve specific records for a limited time while formal legal process is pursued. The purpose is to prevent evidence from being lost due to retention limits or normal data deletion schedules. Preservation requests do not authorize disclosure but create a legal obligation to hold data intact until a warrant or subpoena arrives. For learners, this mechanism reveals the temporal dimension of privacy compliance. Even before disclosure is required, providers must act to safeguard potential evidence, balancing retention policies against new obligations. This adds operational complexity, as organizations must maintain systems capable of freezing data while still honoring minimization commitments for information unrelated to investigations. Preservation requests show how timing intersects with privacy, ensuring investigators are not denied relevant evidence simply due to technical deletion routines. National Security Letters, or NSLs, are another important but controversial access tool. These administrative subpoenas, issued primarily by the FBI, compel disclosure of certain records in national security investigations. Unlike ordinary subpoenas, NSLs often come with non-disclosure provisions, preventing the recipient from revealing the existence of the request. This secrecy has raised ongoing constitutional debates about free speech and transparency. For learners, NSLs demonstrate how extraordinary investigative powers can reshape privacy expectations. Service providers must carefully comply, often with limited ability to contest or disclose to users that their records were requested. The secrecy component emphasizes the tension between user trust and national security imperatives, highlighting how privacy protections can be constrained when investigations touch on terrorism or espionage. Organizations must develop internal protocols for handling NSLs discreetly, while still ensuring accountability through legal counsel and oversight. The Foreign Intelligence Surveillance Act, or FISA, establishes a framework specifically for gathering foreign intelligence within the United States. It created the Foreign Intelligence Surveillance Court, which reviews applications for surveillance targeting foreign powers or their agents. FISA operates differently from traditional criminal statutes, with proceedings often held in secret to protect sensitive operations. For learners, FISA illustrates how intelligence needs reshape ordinary privacy principles. Instead of requiring probable cause for a crime, it focuses on foreign intelligence purposes, creating a different threshold for authorization. Oversight exists but is less visible, leaving many questions about transparency and accountability. Still, FISA underscores that privacy protections extend even into intelligence contexts, with minimization procedures designed to limit incidental collection of U.S. person data. These safeguards reflect the ongoing struggle to balance secrecy and rights in national security environments. Section 702 of FISA further expands these authorities, permitting collection of communications from non-U.S. persons located outside the United States, often with assistance from major service providers. While the law focuses on foreign targets, the incidental collection of U.S. person data has become a major source of concern. Minimization and targeting procedures are intended to restrict how such information is retained and used, but controversies have persisted. For learners, Section 702 highlights the difficulty of drawing jurisdictional boundaries in a world where global data flows are constant. Distinguishing foreign from domestic communications is technically challenging, and the risk of overcollection is high. The requirement for minimization is an attempt to reconcile intelligence collection with privacy protection, though debates continue about whether the balance is effective. This example shows how privacy governance must evolve alongside the globalized nature of digital communication. The USA Patriot Act, enacted after the September 11th attacks, significantly broadened government access powers, particularly through Section 215, which expanded authority to obtain business records. It also enhanced information sharing between intelligence and law enforcement agencies. Supporters argued these powers were necessary to detect and prevent terrorism, but critics raised alarms about bulk collection and diminished oversight. For learners, the Patriot Act exemplifies how crises often accelerate changes to privacy law, shifting the balance toward security during emergencies. The law illustrates how extraordinary events can reshape public tolerance for surveillance, even if later reforms attempt to restore equilibrium. It demonstrates the fluidity of privacy rights in the face of evolving threats and the importance of scrutinizing how expanded powers are applied in practice. The USA Freedom Act sought to roll back some of the Patriot Act's most controversial elements, particularly those involving bulk collection. It limited government authority to request broad swaths of telephony metadata and instead required more targeted queries. It also introduced transparency reforms, including the ability for companies to publish aggregate statistics about government requests. For learners, this reform shows how privacy protections can be recalibrated once the urgency of a crisis subsides. The Freedom Act reaffirmed the principle of proportionality, requiring surveillance powers to be tethered to specific needs rather than exercised indiscriminately. Transparency reporting provisions gave the public more visibility, underscoring the role of openness as a counterbalance to secrecy in surveillance. The Cybersecurity Information Sharing Act, or CISA, further complicates the intersection of privacy and government access by encouraging private companies to share threat indicators with federal agencies. The law provides liability protections for organizations that share such information, aiming to strengthen collective defense against cyber attacks. However, critics worry that these protections may encourage oversharing of data that includes personal information. For learners, CISA illustrates the blending of privacy law with cybersecurity imperatives. Effective sharing can enhance defense, but poorly managed processes risk exposing sensitive consumer information. The liability protections reduce hesitation among companies, but also raise the stakes for implementing strong minimization and filtering practices, ensuring only relevant threat data is shared. User notice practices are another important dimension of government data requests. In some cases, providers may notify individuals when their information has been requested, giving them an opportunity to challenge or at least understand the scope of government access. However, secrecy orders often prohibit such disclosures, particularly in national security or sensitive law enforcement contexts. For learners, this demonstrates the ongoing conflict between transparency and investigative secrecy. Providers must tread carefully, balancing compliance with legal obligations while maintaining trust with their users. Notice practices, where permitted, reinforce fairness and autonomy, while secrecy reflects the reality that privacy protections sometimes yield to broader investigative priorities. Finally, transparency reporting has emerged as a best practice for companies handling large volumes of government requests. By publishing aggregate statistics about the number and types of requests they receive, companies can give the public insight into the scale of government access without violating secrecy orders. For learners, transparency reporting demonstrates the principle that even when full disclosure is not possible, openness at the aggregate level can foster accountability and trust. These reports highlight patterns and provide context, showing that privacy compliance is not only about responding to each request, but also about communicating with society about the broader balance between individual rights and government needs. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. When organizations receive a government or court request for user data, the first step is to verify the validity and scope of the legal process before disclosing anything. Not every document that looks official grants lawful authority. and not every request is properly tailored to the data sought. Companies must review whether the request is a subpoena, a court order, or a warrant, and confirm that it comes from a jurisdiction with authority over the provider. For learners, this demonstrates how compliance is not about blind obedience, but careful due diligence. Verifying process ensures that organizations do not overstep, releasing information that is not lawfully demanded, and it reinforces trust that privacy is guarded even in the face of legal pressure. Responsible practice demands treating requests as serious but not automatically valid until verified. Once a request is verified, the principle of narrow tailoring becomes critical. Organizations should disclose only what the legal order authorizes, applying minimization techniques or redaction where possible. This means producing the specific records or account content demanded, while removing unrelated fields that might expose more than necessary. For learners, this underscores how privacy can be preserved even within compliance. Just as surgeons remove only diseased tissue while leaving the rest intact, data custodians must excise only what is relevant to the request. Over-disclosure not only risks violating privacy rights but also undermines legal protections. Minimization practices reflect a mature understanding that lawful access and privacy protection are not mutually exclusive. They are carefully balanced through discipline and scope control. Cross-border requests add another layer of complexity, especially in a world where data often flows across multiple jurisdictions. Mutual Legal Assistance Treaties, or MLATs, are formal processes for one government to request data held in another country, but these processes can be slow. Increasingly, direct requests are made under new frameworks or through informal cooperation, raising questions about sovereignty and compliance. For learners, this reveals the global tension between local privacy laws and international investigative needs. A company may face conflicting obligations, comply with a foreign order, or risk violating domestic privacy statutes. Addressing these challenges requires legal review, policy frameworks, and sometimes diplomatic mechanisms, showing that privacy governance in cross-border contexts is as much about negotiation as about technology. Data mapping readiness is essential for responding effectively to legal demands. An organization that cannot quickly identify where account data, logs, or content are stored risks either underproducing or overproducing in response. Data inventories, retention schedules, and mapping tools ensure that teams know where information lives, whether in on-premises servers, cloud environments, or backups. For learners, this illustrates how strong internal governance translates into compliance confidence. Just as a well-organized library allows a quick retrieval of a book without handing over the entire catalog, data mapping lets organizations respond precisely without exposing excess. It turns the theoretical principle of minimization into a practical reality, rooted in disciplined knowledge of one's information assets. Maintaining evidentiary integrity is another obligation when producing records. Logging every step, preserving chain of custody, and ensuring data has not been tampered with are essential for evidence to be admissible in court. This means carefully documenting who accessed the information, how it was extracted, and how it was transferred. For learners, this requirement shows how privacy compliance overlaps with forensic science. The credibility of a production depends not only on scope but also on integrity. A sloppy or undocumented handoff risks both undermining the case and violating privacy commitments. Evidentiary discipline therefore protects not only the legal process, but also the organization's reputation as a careful custodian of user data. Civil litigation demands present a parallel challenge, often arising outside of government investigations. Companies may receive discovery requests and lawsuits, which can be as broad as criminal subpoenas but carry different rules. Coordinating responses requires legal counsel to ensure privacy commitments are respected while still fulfilling obligations to the court. For learners, this demonstrates that data governance is not only about government scrutiny but also about private disputes. A company must balance duties to litigants with privacy promises to users, applying the same minimization and documentation principles. Civil discovery therefore becomes another arena where privacy law, contractual obligations, and legal compliance intersect. Requests involving journalists and media organizations require heightened protections. Federal law and Department of Justice guidelines restrict newsroom searches and subpoenas to protect press freedom and First Amendment values. For learners, this highlights how privacy principles can align with democratic safeguards. Protecting sources and preventing chilling effects on journalism are integral to maintaining a free press. Organizations must treat media-related requests with special scrutiny, often escalating them to senior legal and compliance teams. This reinforces the broader idea that not all data requests are equal-sum-touch constitutional values that demand additional layers of review, sensitivity, and documentation. E-discovery in corporate litigation also illustrates the tension between disclosure and privacy. Large-scale production of emails, documents, or databases must be filtered for relevance while protecting sensitive personal information about employees, customers, or partners. Privacy-respecting production methodologies such as anonymization or redaction ensure compliance without overexposure. For learners, e-discovery shows how privacy risks do not arise only from government pressure. Internal disputes, regulatory reviews, and private lawsuits all create disclosure obligations that must be carefully managed. Building strong e-discovery protocols is therefore not only about legal efficiency but also about safeguarding the trust and dignity of individuals whose data may be swept into litigation. Third-party processors and vendors play a central role in how organizations respond to government requests. Cloud providers, SaaS platforms, and outsourced processors often hold significant portions of data and must be aligned contractually with the primary organization's obligations. Flow-down provisions in contracts ensure that processors respond appropriately and within legal boundaries. For learners, this illustrates the principle of shared accountability. Privacy obligations cannot be outsourced, and companies remain responsible for ensuring their vendors respect the same due process and minimization standards. Vendor coordination is therefore a vital part of compliance, as a single weak link can compromise both legal integrity and user trust. Some categories of data require especially careful handling when subject to requests. Health records, financial details, biometric identifiers, and children's information carry heightened legal and ethical sensitivities. Producing such records often requires not only legal process but also additional redaction, encryption, or special authorization. For learners, this highlights the layered nature of privacy protections. Just as some locks are stronger than others, some datasets deserve stricter controls. Recognizing these heightened obligations ensures that organizations approach sensitive records with caution, aligning disclosure practices with both legal requirements and broader ethical duties to protect the most vulnerable forms of personal information. Retention policies must also be reconciled with legal hold obligations. Organizations may strive for minimization by deleting records once they are no longer needed, but when a preservation request or litigation hold arrives, deletion must be suspended. For learners, this reveals how privacy principles can collide with evidentiary requirements. Minimization is the default, but preservation overrides it temporarily. Effective governance requires clear policies and workflows to balance these competing demands, ensuring that data is not destroyed prematurely while also preventing unnecessary accumulation once the legal obligation ends. Incident response planning is critical when requests are unauthorized, overbroad, or suspicious. Organizations must be able to detect anomalies, escalate concerns, and, where appropriate, resist compliance until clarification or correction is provided. For learners, this demonstrates that compliance does not mean passivity. Just as cybersecurity programs prepare for breaches, privacy governance prepares for improper legal demands. By embedding escalation protocols, companies protect themselves from becoming conduits for overreach, reinforcing that privacy duties persist even under pressure. Incident response thus extends beyond technical compromises to encompass legal and regulatory resilience. Documentation is indispensable for defending response decisions. Organizations should compile packages summarizing the request, the verification process, the scope of data disclosed, and any minimization or redaction steps applied. These records provide evidence for regulators, courts, or internal reviews that the organization acted responsibly. For learners, documentation underscores that privacy is a practice, not an aspiration. It must be visible, reviewable, and auditable. In the absence of such records, even responsible actions may appear arbitrary or negligent. Documentation, therefore, becomes a shield of accountability, demonstrating compliance in both substance and form. Governance cadence ensures that lessons from past matters feed into future readiness. Policies must be reviewed regularly, staff must be trained on evolving legal standards, and post-incident reviews must identify areas for improvement. For learners, this final step emphasizes that privacy is dynamic. Laws evolve, investigative tactics change, and public expectations rise. Organizations cannot treat government request compliance as static. Instead, they must embed a culture of continuous learning, adapting their processes to maintain alignment with lawful bases, strict scope control, and transparency where permissible. Governance cadence turns one-time compliance into a sustainable program of resilience and accountability. In conclusion, Domain 3 demonstrates how privacy governance intersects with government access, legal process, and organizational duty. Effective practice requires verifying every request, tailoring disclosure narrowly, protecting sensitive categories with extra caution, and documenting every step of the process. Cross-border complexity, vendor coordination, and evolving statutes ensure that challenges will continue, but disciplined governance ensures organizations uphold both legal and ethical duties. For learners, the lesson is clear. Lawful access and privacy are not opposites, but complementary principles achieved through diligence, scope control, transparency, and ongoing refinement of organizational practices. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.